Start. The additional sessions judge also did not consider the foundational illegality committed by the SDM and repeated the same because the person whose interest was being affected was never heard at the initial stage. Stop. The proviso to Section 17, subsection 2 explicitly mandated that before ordering the confiscation of the said vehicle, a reasonable opportunity of being heard shall be afforded to the owner of the said vehicle. Stop. In the present case, the competent authority did not grant any opportunity at all to the vehicle's owner what to speak about a reasonable opportunity. Stop. Thus, while passing the order of confiscation of the vehicle, the competent authority neither provided any opportunity to the vehicle's owner nor was the vehicle's owner heard. Stop. However, Section 17, subsection 5 of the statute, the Haryana Govansh Sanrakshan and Go Samvardhan Act 2015 under bracket HGSG Act bracket close mandates that any person aggrieved by an order 4 made by the competent authority under subsection 2 or subsection 4 may within 30 days from the date of such order prefer an appeal to the Deputy Commissioner of the district concerned. Stop. The petitioner did not file any appeal under Section 17, subsection 5 of the HGSG Act and instead filed a criminal revision petition before Sessions Court. Stop. Para. Further, the legislature has also taken away the jurisdiction of courts, tribunals, or other authorities regarding the confiscation of vehicles and has conferred such jurisdiction only to the competent authority. Stop. The proposition of law that emerges is whether the Sessions Court and the High Court on the criminal side have jurisdiction under sections 397, 399, 401 and 482 of CRPC 1973 or sections 438, 440, 442 and 528 of BNSS 2023 to check the correctness, legality or propriety of an order passed by the competent authority under the HGSG Act when either the vehicle's owner is not heard at all or the competent authority or the Deputy Commissioner did not provide a reasonable opportunity of being heard. Para. The High Court or any Sessions Judge may call for and examine the record of any proceeding before any inferior criminal court situate within its or his local jurisdiction for the purpose of satisfying itself or himself as to the correctness, legality, or propriety of any finding, sentence, or order recorded or passed, and as to the regularity of any proceedings of such inferior court, and may, when calling for such record, direct that the execution of any sentence or order be suspended, and if the accused is in confinement, that he be released on his own bond or bail bond pending the examination of the record. Stop. Para. The powers of revision conferred by subsection 1 shall not be exercised in relation to any interlocutory order passed in any appeal, inquiry, trial, or other proceeding. Stop.